Hey guys, welcome to Module 1 short lecture. Now this week, the focus of this lecture is going to be on the Constitution and the Bill of Rights and an overview of the 4th, 5th, and 6th Amendments. And then I'm going to highlight a little bit about the rule of law and how it applies to the criminal justice system. So let's first start by looking at the purpose of the Constitution. And this is going back to your civic days in junior high or high school. The purpose of the Constitution was to establish a central government authorized to deal directly with individuals rather than states, and to incorporate a system of check and balances that would preserve the fundamental concepts contained in the Magna Carta, that is, to limit the power of government. Now, the system of checks and balances that is mentioned here is something that carries over today in our criminal justice system, and we'll explain that here in just a little bit. Now, the first three articles of the Constitution established the legislative, executive, and judicial branches of government and the country's system of checks and balances. So first we'll start off with the legislative branch. Now, the legislative branch may pass laws, but it has no power to enforce or interpret them. So typical legislative branches of government would be Congress, your state legislative branches, your state assembly, county board of supervisors, and your city council. Those are considered legislative branches of government. The executive branch was created to carry out the law. And so for the criminal justice system, for example, law enforcement is considered part of the executive branch of government. Now, the judicial branch, and the power lies with the courts, but judicial jurisdiction is controlled by legislative bodies. What that means is courts have jurisdictions only when the controlled legislative bodies create laws that give it the authority to hear those type of cases. So, for example, federal courts get their judicial power or jurisdiction from Congress. State courts get their judicial jurisdiction from state legislative bodies and so forth. Okay? So, but these three legislative branches, these three branches of our government, is what provides us that checks and balances. And this can very well apply to our criminal justice system. And we'll explain that a little bit further. Now, there's always been this conflict between federal power and state power. The fact that powers not specifically delegated to the federal government were reserved for the states and the people has been a big issue. Many court cases and policy debates resolve around this issue, right? And one of the ones that we're dealing with today, and we'll talk about this later on in a couple modules in the future here, is the debate about illegal immigrants, sanctuary cities, and states, all right? And that'll be important, I think, in Module 6, where we will grapple this idea of how this power struggle, so to speak, comes into play in terms of the criminal justice system, all right? So just think about this again for a second. Just keep this in the back of your head there until we get closer. But understand that there is this ongoing power structure between the federal and state governments and who has power and authority over certain things, okay? So just keep that in mind. Now, federal and state power, we'll talk about checks and balances. Now, the Constitution established an effective system of checks and balances on the power of any one of the three branches of government. And that's the important thing you need to take away from this idea of checks and balances. And we could apply it to our criminal justice system, all right? Because the legislature passes laws. Police then enforce those laws. And the courts then interpret those laws. And where necessary, hold people accountable. So, for example, if the legislature were to pass a law and the police were to enforce the law, the court's job might be to interpret that law. For example, maybe the law is unconstitutional, right? But the police were enforcing the law. And so that's the system of checks and balances that we have here in this country. Although the legislature can pass the laws and the police can enforce the laws, it's up to the courts to determine whether or not those laws are in fact constitutional. And if they are constitutional, then their job is to protect the rights of the individual charged with those specific types of crimes as their case moves to adjudication. All right, so that's the important part of this whole idea of checks and balances that we are dealing with. So we can benefit or say that the Constitution is what supports this idea of checks and balances, and it does so at the federal level. And in many states constitutions pretty much mirror the federal constitution, and so it limits the power of each of those. For example, in your home state, your governor has so much power, so there's a legislative branch and the executive branches, which again would include the governor, but also would include law enforcement. And so there is that idea of the judicial, legislative, and executive branches at all three levels of government, local, state, and federal. And so the concepts of checks and balances can apply there as well. Now, the Bill of Rights came shortly after the Constitution. The framers of the Constitution sought to balance the powers of the legislative, executive, and judicial branches of government. The proposed amendments aimed at balancing the rights of the states and of individual citizens against the powers of the central government, and now also the states, because now the Bill of Rights now applies to the states. Originally drafted, the Bill of Rights only applied to the federal government. Later Supreme Court decisions ruled that the Bill of Rights applies to individual states as well. So the Bill of Rights applies to you no matter where you are, okay, in the country. All right, so in 1791, 10 amendments known as the Bill of Rights were added to the Constitution to ensure the individual rights of American citizens, and that's critical. Now, it doesn't necessarily have to be American citizens. Basically, the Bill of Rights applies to anyone within the jurisdiction of the United States. So, if you're in the country illegally and you commit a crime, the police still have to follow the Fourth Amendment if they're going to do any type of arrest or search. They have to follow the Fifth Amendment if they're going to interrogate you. And then you're entitled to legal representation under the Sixth Amendment. So whether you're a legal citizen or not a legal citizen, the Bill of Rights applies to anyone within the jurisdiction of the United States. And that's an important point because, like I said, later on down the road, I think in Module 6, I could be mistaken, but 5, 6, you're going to be dealing with this issue of trying to explain the rights to someone who may not understand what their rights are. So just know that the Bill of Rights applies to anyone under the United States jurisdiction. Some other caveats: the Bill of Rights was enacted to protect all citizens from excessive governmental powers. Criminal justice professionals must conform their behavior to the rule of law as set forth not only in the U.S. Constitution, but also in the state constitutions. Statutes enacted by state legislature, municipal ordinances, and the precedent of prior interpretation by the courts. So that's the basic principle of the rule of law. So something you need to pay attention to, the basic principle of the rule of law. Okay, so highlight that in your notes or whatever the case may be, but just pay attention to that concept related to the rule of law. Now, the law is dynamic, which means it's constantly changing. And so as society changes, society's values changes, for example, laws begin to change. Court decisions might change, all right? And we'll learn about some of those. You'll see how some of those have changed over the years when you start looking at, for example, search and seizure issues. And one of the cases that you'll be looking at involves the use of a cell phone and whether or not police have the right to search your phone as incident to an arrest. We'll talk about that in just a little while. But pay attention to that case as you start trying to understand that the law is always changing based on what's taking place in society today. And so as things change, as technology changes, then the courts are going to have to change their overview of what, for example, what police can and cannot do uh, as far as searches and those kind of things, whether it be incident to arrest or whatever the issue might be. All right, so just remember the rule of law is very important to remember, and then that the law is very dynamic, it's constantly changing. So the courts have to change with that, changes that are going on in society, and changes in the law that take place and technology and so forth. So let's talk about the Fourth Amendment. I'm not going to read this out to you because you can read it yourself. But I think it's remembered to know that the right of the people to be secure their persons, houses, papers, and effects against unreasonable searches and seizures. All right. So what that means is unreasonable is the courts have to interpret that for us. Okay. Notice the founding fathers didn't tell us what a reasonable search was. They just said unreasonable. They led it to the courts to decide whether or not the actions of the government, typically the police, the actions were reasonable or unreasonable. Shall not be violated and no warrant shall be issued but upon probable cause. And this is an important concept that you'll learn more about in this class and other classes down the road. But just understand that a person is secured in his person, houses, persons, and effects against unreasonable searches and seizures. And that in order for police to search or arrest someone, they have to have probable cause. So the Fourth Amendment is outlined, the Bill of Rights is outlined in our textbooks on pages 438 to 441, so take a look at that there. It's intended to limit the overzealous behavior by the police. Primary protection is a requirement that a neutral magistrate issue warrants for arrest and searches, arrest warrants, search warrants, and so forth. A neutral magistrate has to review those and determine whether or not there is sufficient probable cause to warrant an arrest and search of a person's property, personal effects, things like that. Probable cause, a reasonable basis to believe that a crime has been committed, for example, when we're talking about arresting somebody or is about to be committed by a particular person. It also applies to searching, whether or not it is more likely than not that the item you're going to seize is going to be found inside a particular residence, for example. Search and seizure, an officer searching for and taking away evidence from a crime. That's the concept of search and seizure. So if I take something, I'm seizing something. All right. In order for me to seize and search for something, I would have to have probable cause or one of the exceptions, which we'll talk about in just a little bit. Now, the courts developed the exclusionary rule in 1961 that basically says that evidence obtained improperly cannot be used against an accused at trial. We talked about the first appeared in the U.S. Supreme Court case, Weeks versus the United States. That was a federal case in 1914. And in Mapp versus Ohio in 1961, the exclusionary rule then applied to the states. Prior to 1961, state courts did not have to follow the exclusionary rule, but the federal courts did, federal agents, federal law enforcement. Now everyone has to follow. So basically, anytime the police seize something from you and they did so illegally, it cannot be used at trial. So you can start looking at the David Riley case, which begins on page, I think, 201 of our textbook. It's the search of a cell phone without a warrant. They did so incident to an arrest, and you can take a look at that and decide whether or not you think that was proper. Arrest with or without a warrant. We talk about an affidavit in the Fourth Amendment. It's a written document in which the signer swears under oath and the statements in the document are true, in which they establish probable cause. The Supreme Court has required police officers to obtain a warrant when making a felony arrest unless exigent circumstances are present. Now, if you witness a crime, you don't need to get a search warrant. Obviously, you can arrest someone because it's a crime committed in your presence. Otherwise, you should have an arrest warrant. Must have probable cause to stop an individual or a vehicle. In other words, you must have a reason to stop someone, such as a traffic violation. Okay, I'm going to stop right here and we're going to go to section 2. So hang on just a minute, guys. Thank you so much.